What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And in this episode, we take a look at another issue involving the UFC Antitrust Lawsuit. No, it is not the class action certification that we're all waiting for. It's related to another issue regarding attorney advertising. Now, imagine if you did worked on a project, did all the due diligence, got clients, got all the research done, did all of that, and getting ready for the big moment for your payoff, and realize that someone else is going to swoop in and try to take all the credit for that. Well, that is similar to the case that's happening right now related to plaintiffs' attorneys filing an emergency motion to compel a outside law firm, the Sparacino law firm, to stop communicating with potential class action members in the UFC lawsuit. Now, we're going to get into the details of this in this episode, but just to let you know, I made one incorrect statement in my video presentation, which you'll see in a second, and that's related to the fact that the Sparacino law firm did not contact any of the individuals named in the lawsuit. They in fact did, but of course those people know that they were represented by their own attorneys and not this third party. So the overarching issue here is that a third party law firm is looking to take a portion of the class members in this lawsuit, having the fact that the plaintiffs' attorneys in this lawsuit have spent a long time, since 2014, regarding filing and battling motions and battling ZUFA and battling third parties to obtain documents. All of that now comes to a head as Judge Boulware is slow playing this class action opinion. Now, before that, it appears that the plaintiffs want some sort of ruling related to this law firm trying to intervene and advertise. It brings up the question of whether attorneys can advertise and solicit clients from other attorneys and represented parties. It looks at a rule of professional conduct as far as whether or not this is legal, and if the court can actually enforce something like that. In my experience, courts don't like to intervene regarding rules of professional conduct unless it's egregious and it deals with a direct issue related to attorney and individual, a client or a witness or something like that. So here is my summation of the plaintiff's emergency motion in the ZUFA antitrust lawsuit. So on March 30th, plaintiffs in the ZUFA lawsuit filed an emergency motion to compel the Sparacino PLLC law firm to stop communicating with absent members of the proposed class and for related relief. Notably, they requested an oral argument before Judge Boulware, or at least the magistrate judge that would determine these types of discovery disputes. This is related to some mailers that ex-UFC athletes that were going to be a part or were contemplating being a part of the class action lawsuit about the possibility of representing them in the lawsuit. Now, the reason why the plaintiffs are upset and have filed this motion is because that at this point, prior to the opinion being filed by Judge Boulware, the plaintiffs are the de facto class action attorney representatives. Now, while there hasn't been an opinion filed, it's almost certain that the class action's class status will be certified by Judge Boulware as it relates to the bout class. And the attorneys that have spent all their time, energy, and money want to make sure that in the end that they are the attorneys for the plaintiffs think that a law firm like the Sparacino law firm is essentially cherry picking at this particular point. Now, the attorneys for Kung Lee, Nate Quarry et al. have indicated that there was one mailer which gave the recipient a breakdown of the lawsuit, but omitted some issues as far as the lawsuit, and also indicated that they had to act in terms of deciding whether or not to join the lawsuit or retain their own attorney. A second mailer was sent to, clarify the first mailer, and that the second mailer was in response to plaintiffs' attorneys getting wind of the mailer and telling the Sparacino law firm to stop doing that. Now, the second mailer, clarified that, but also with the clarification also indicated that there were other options out there aside from the attorneys that have filed the lawsuit. So there is a dual issue here. First, there is the attorney advertising, the outset, the mailer, and then secondly is the clarification, which also is another way of advertising. The Sparacino law firm indicated in its advertisement that while it may not be experts in antitrust litigation, it is very experienced in high-profile litigation, and indicated to the people that received the mailer that they had partnered with a law firm that specialized in antitrust litigation. According to its opposition to the motion to compel, the Sparacino law firm indicated that due to the plaintiff's attorneys aggressively dissuading the advertisements, that the associated law firm that had an antitrust experience decided to bow out of any potential representation. Also, Sparacino law firm claimed that for the most part the arguments made by plaintiffs' attorneys was overbearing, misrepresenting the advertisements, also claiming that they had a right to advertise. They also stated that in the second mailer that they clarified their position. Now, they also potentially could argue that due to the fact that the plaintiff's attorneys made an aggressive stance toward their advertisements, that the attorneys for Sparacino might have an actual tortious interference with a potential business relationship. Now, I don't think that that's going to happen, but it certainly, according to the pleadings, it indicated something of that nature. So another issue here is the issue of plaintiff's counsel's request to enforce RPC 4.2, the Rules of Professional Conduct for Attorneys. The Rule 4.2 indicates that lawyers cannot communicate with persons whom they know are represented by counsel about the subject of representation. It's a way to ensure that lawyers don't try to poach clients at a time when the client has signed an engagement agreement with his attorneys. Now, I don't particularly know of any huge case in which a court has intervened to enforce a rule of professional conduct. Usually these rules are things that attorneys must abide by regardless, and usually the enforcement does not happen through a court unless it's egregious. And I would suggest to you that Sparacino will say that they did not break any rule. In fact, they said that it was a half-hearted suggestion by plaintiffs' counsel that they violated RPC 4.2. Certainly, there are nuances to how an attorney can advertise and how it can communicate with clients, but I believe Sparacino here is making the argument that the fighters that they reached out to were not represented by the attorneys at the particular time. So they indicate in their pleadings that there is limited relevance in the context of class action proceedings prior to the certification of a class. And here, despite the fact that there are intimations by Judge Boulware that he is certifying a class, Sparacino is technically correct that the class has yet to be certified. There's no order yet. So they can still contact, if they want to, potential clients of this class action lawsuit. That's the argument, and I think that's a valid argument right now. Plaintiffs do assert that the advertisements were pointed and made an attempt to confuse or misrepresent the issues at hand, and perhaps forced someone to sign with the Sparacino law firm. That would be what the plaintiffs would argue. In fact, there is a declaration from Rob Macy which indicates that there were fighters that reached out to him that were confused about the mailer. But the question is whether or not a court will enforce this. Now you have to ask, what exactly do plaintiffs' counsel want? So in its filing with the court, it requested seven specific things to be accurate, and one of them is the first one is to ensure that Sparacino abides by its representation that will cease sending communications to or otherwise contacting absent members of the class. Secondly, it compels Sparacino to provide counsel appointed to represent plaintiffs and the proposed broadcast with copies of all communications previously sent to absent class members. We'll get to that in a second. The third one is compelling Sparacino to provide class counsel with all of the names and addresses of the absent class members. 4, compelling Sparacino to provide counsel with a list of any recipients. You can see where this is going. 5, compelling defendant Zufa to provide class counsel with a list of all persons included with the definition of the proposed ballot class. 6, permitting class counsel to send a letter to all members of the proposed ballot class substantially in the form attached to Eric Kramer's declaration. 7, providing that any absent class members who have retained Sparacino shall have 30 days from the date on which they receive a coercive letter to rescind their agreement. So you can see that the request by plaintiffs is a little overreaching, if you could say that. Aside from number 1, compelling Sparacino to abide by its representation that it will stop sending communications, there is a request to receive information gathered by Sparacino and to provide it to the plaintiff's counsel. There's also a request for Zufa to do something in all of this, and the final one, which I am sure it was which is opposed by Sparacino, is that any fighters that signed on with Sparacino have a right to rescind their agreement. In its filings, the Sparacino law firm indicated that at least 11 fighters had signed an engagement agreement with them to at least represent them in determining their rights, their individual rights as fighters, as it relates to the class action lawsuit. So that seems to be a huge sticking point, because no one wants someone to rescind. And also, as far as the obtaining all the names and addresses, that seems a little overbearing, a lot to give to plaintiffs' counsel. Obviously, plaintiffs will argue that they should not have been advertising and violated RPC 4.2 regarding trying to target people that were in a class of people that were represented already. But this seems like something where plaintiffs are asking for a lot and hoping to get something in the middle. So what do you think? What do I think the judge will do in this particular case? It's hard for me to foresee the plaintiffs getting everything they want in their emergency motion. Also, I don't think that they're going to get oral argument as it is. It's mainly going to be something where the judge or magistrate will determine it on the papers, on the pleadings, everything that's filed. I don't see a judge enforcing RPC 4.2. I don't think that Sparacino did anything egregious. Certainly they moved to the edge of perhaps the RPC, but nothing in which they had made overtures to people who were knowingly represented. Certainly there is the argument that the people that were contacted were maybe confused about the situation, but it's with this filing, it's been clarified. I foresee that the court will request that all parties work it out on their own and report back to the court. I don't think that a court order at this particular time will be sufficient, and there always is the potential of other attorneys and law firms coming in and attempting to solicit clients. Again, it's something we need to follow. So with all of that being said, there's nothing as of this date, May 7th, that has come out regarding any determination, notice, or order from the court. Certainly, their court is busy. They are taking this under advisement. Whether or not a judicial magistrate will intervene, obviously, that could happen as well. The magistrate is kind of like a discovery referee in a way, and can intervene in these types of situations regarding issues of discovery. But I would suggest that this maybe is bigger than that, because it relates to an outside party, and of course plaintiffs are making a big deal of it, as they probably should, because if this motion is denied, you could see other law firms coming in and trying to advertise to potential class members. So we will follow this, and we will also follow the rest of the mechanics of the UFC Antitrust Lawsuit. It is Jason Cruz. Please subscribe to the YouTube channel. Follow me on Twitter. Do whatever you want. Jason Cruz, Legal Submission, MMA Payout. Have a good night.